Yes, sir, Mr. Calero, I can hear you.
Thank you. Thank you for being here. We are on the record in Department 10 in the matter involving the Robinson children. We are here in a Marsden hearing. The courtroom is cleared here. The only people here are court staff. I have clerks, court reporter, and a deputy here in the courtroom. We have Mr. Moore participating on Microsoft Teams and Mr. Robinson participating on Microsoft Teams. I will be hearing this Marsden proceeding. I want to note that these proceedings are confidential. It's a closed courtroom. I also want to note that because you will be telling me, Mr. Robinson, about your communications and your interactions with Mr. Moore, that for purposes of this Marsden proceeding, attorney-client privileged information will likely be discussed, and that's one of the reasons why this proceeding is closed. So, Mr. Robinson, it's my understanding that you are requesting to have new counsel appointed to represent you. Is that correct?
Yes, sir.
Okay. So, under the law, you can have your current appointed attorney discharged and a substitute attorney appointed, but you have the burden to demonstrate with substantial facts and reason that your right to assistance of counsel has been impaired. So, I have some questions for you. I'd like you to tell me the reasons why you feel your current attorney should be replaced.
Well, because he has tried to persuade and coerce me into believing that my rights are not absolute when in fact they are. So there has been deprivation of my rights, and to put it simply, there's been constitutional violations and civil violations within this courtroom and dealing with this CPS organization that have been completely overlooked and swept under the rug. And
all right, can you elaborate on some of that for me, sir?
Well, there's definitely been a violation of due process. I've reviewed some of my paperwork. The first 5 court hearings I knew nothing about. None of us knew nothing about. Maybe the mother did. I don't know, but I knew nothing about. So I finally appeared telephonically when I heard about them trying to approve my kids to go to the Dominican Republic. See, we have a constitutional right over our kids, and that's being overlooked and completely circumvented. They're directly circumventing the Constitution. The thing is, me or the mother have not lost our we have not had our parental rights terminated. And the judge made an approval to send my kids to the Dominican Republic with strangers. And we had no court hearing about this. My lawyer didn't tell me about this. Nobody told me about this. I didn't know the judge approved it until he told me today. So in my personal belief is he is not representing me or my children, the best interests of my children, adequately enough.
Okay. Before I ask you another question, I want to make sure that you have had an opportunity to tell me all of your concerns. So I heard you say that you believe that there have been constitutional violations, for example, due process violations. You disagree with an order that was made either detaining or placing your children in the Dominican Republic. Is there anything else? Any other examples?
These are not examples. There's been a direct circumvention and violation of constitutional and civil rights. And I do not believe that the state court can house this. I think this needs to be moved to federal court because of these constitutional and civil rights violations. So, with that being said, my own representation trying to persuade and coerce me out of my rights when I know that my rights are absolute, that is, I'm not sure of the correct terminology, and I have a disability in not understanding the language of the law, legalese, so you have to accommodate me. But that is not supposed to happen. He's not supposed to tell me that, and not supposed to persuade me and coerce me into believing that my rights are not absolute, because they are. They in fact are.
All right, so I have 2 other questions for you.
Yes, sir.
The first question is, has Mr. Moore failed to do something that you think he should have done?
Yes, I believe he failed to represent me and my children adequately when there has been no child abuse or neglect found. Your welfare and institution codes they are irrelevant to the Constitution. And like there's no case here. This case has been fabricated and this case has been case fixed. So there is no case, and this case should have been dismissed, especially with the fact that the reports say there is no child abuse or neglect. This case should not be here. And now with the constitutional and civil violations, it should be held in a federal court, it's federal Supreme Court.
Are there other things that you believe Mr. Moore failed to do?
He failed to represent me adequately.
Okay. Are there things that you think Mr. Moore did that he should not have done?
Tell me that my rights are not absolute. Persuade and coerce me into believing that my rights are not absolute. Depriving me of my rights.
How did he deprive you of your rights?
By telling me that my rights are not absolute, telling me that I could get put in jail for using my freedom of speech, and that in fact is not true. You cannot threaten me for following constitutional law. You cannot threaten me. I may not excel in the language of the law. I may not have taken law school, but I know my rights as a natural living being.
Right. At this time, is there anything else you want to share? Let me tell you what's going to happen next. After you provided these comments, then I'm going to go to Mr. Moore and ask him if he has any response to what you've shared with me. Then I'm going to come back to you.
Yes, sir.
So this isn't this is not your last opportunity, but I want to make sure, and I ask you right now, is there anything else you want to tell me now?
No, sir, that is all.
Okay. Thank you very much. Please hold on. Mr. Moore, do you have any response?
Thank you, Your Honor. I believe Mr. Robinson is a bright individual who has taken a lot of time and effort to try and acquaint himself with the law and specific terminology. I think much of the disconnect is that he has a belief as to how things should be, and is dissatisfied with how things are in terms of the law. I do want to correct one thing, Your Honor. There was not a placement or a detention order for the children to be in the Dominican Republic. It was a travel request made by the caregivers near the outset of the case. Mr. Robinson's objection was brought to the court's attention and was known. With Mr. Robinson's due process objection was that this was an order that was granted ex parte. I tried to explain to Mr. Robinson that caregiver travel requests are routinely granted ex parte, that Mr. Robinson's prior instructions to me regarding what I should do in the case effectively limited me from setting the matter for a special hearing. At the adjudication, Mr. Robinson indicated that he did not believe this court had authority to make orders. It did not have jurisdiction to make orders, and that the only way the court would have jurisdiction to make orders is if he voluntarily contracted with the court. I explained to him that this is not something that has a basis in law. I explained that the court would take jurisdiction if it found by preponderance of the evidence that the allegations in the petition were true. Mr. Robinson, after several hours on the phone with him, finally terminated the phone call prior to the adjudication with the instructions that he was going to text me exactly what he wanted me to say in court and nothing further. I again explained to him that that was going to hamstring my ability to effectively advocate for him with things that he might want the court to do. Since then, Mr. Robinson has sent various cases don't particularly apply, and most recently this morning, I've not had an opportunity to do so. He sent me about 6 cases this morning that I will certainly respond and let him know how those cases might apply to this particular case, if they do at all. But I've maintained regular and consistent contact with Mr. Robinson. I have taken great pains to explain to him the application of the law, the relevant welfare and institutions codes, California rules of court, as well as the relevant case law that the court uses in deciding these cases. I believe a lot of the conflict, Your Honor, lies in Mr. Robinson's dissatisfaction that he does not like the answers that he's getting.
No, I'm looking. I'm sorry.
1 second, Mr. Robinson. I'm going to come back to you, okay?
I apologize. My apologies.
It's okay, sir. Thank you. Mr. Moore, anything else?
I believe that I have provided the best possible representation to my abilities and fulfilled my duties to the bar and the Constitution and my client. Mr. Robinson has his own ideas about how the law should work, and I've offered him the ability to represent himself as well. He does not wish to do that. But I believe that I can continue to provide him competent and quality legal representation that is consistent with my duties under California and federal law.
Right. Mr. Robinson, anything else?
So, yes, in the Santosky versus Kramer case, the Supreme Court agreed with the Santoskys, ruling that the standard of proof for revoking parental rights should be clear and convincing evidence rather than a preponderance of the evidence.
Mr. Robinson, can you please slow down and repeat what you said? We do have a court reporter here who is transcribing the proceeding, and I want to make sure everything you say is being captured. So if you could start again and slow down.
Yes, sir. In the Santosky versus Kramer case, 1982 Supreme Court, the Supreme Court agreed with the Santoskys, ruling that the standard of proof for revoking parental rights should be clear and convincing evidence rather than a preponderance of the evidence. The court found that the preponderance of the evidence standard created a substantial risk of error and favored the preservation of familial bonds. So I wanted to read that. That's what I wanted to read, because the thing is, the reports, their own CPS reports, which somehow has been overlooked, have stated that their reports do not meet the statutory criteria for child abuse or neglect. There is no child abuse or neglect. Yet me and the mother as well have been alienated from our children. We have been deprived of our constitutional rights to the care and upbringing of our children when there is no child abuse or neglect. And these issues should be addressed aggressively, and they have not been addressed aggressively. They have been overlooked. They have been circumvented along with our Constitution, just all of our constitutional rights that are involved in this. And that's the issue. So that's my issue. It's not what I believe. It's not my idea. It's what the Supreme Court says and what the supreme law of the land says. And we have rights, and our rights are being suppressed, which is a form of corruption. And the thing is, I've asked him and I've explained this to him, and I don't understand how my kids got approved to go to the Dominican Republic against me and the mother's wishes when we have a constitutional right over our children. Our rights haven't been terminated. And it seems Mr. Moore is not willing to argue and address these situations. He would rather argue with me and debate with me in the midst of defending these other people.
Anything else, sir?
No, sir.
All right. Well, first I want to note that the sole issue before me today is whether Mr. Moore should be replaced. With regard to the travel request, that is not before me, was not before me. I understand that you have concerns about that, but that issue is not before me. I just want to make sure you understand that. And I have no issue with you bringing that up and explaining your concerns, but I just want you to be aware that I am not here to decide on that independently, okay?
Of course, but these are my concerns in regards to Mr. Moore specifically. I understand that you have no say-so in that matter. I understand.
And I understand that that is one of your concerns, Mr. Robinson. I do understand that. So there are grounds that have been determined as sufficient to sustain a request to have new counsel appointed, and then there are grounds that have been deemed to be insufficient. And what I hear you saying is that you do not believe that Mr. Moore has your best interests at heart, that you disagree with his positions, with his strategy, with his tactics, and that he is not conducting the case as you wish him to.
Yes.
Those grounds, sir, are insufficient to provide you the request you're seeking today. And so,
based on what? Can you elaborate for me and explain to me why?
Courts have held that there are certain grounds that are sufficient to grant the request that you're asking for, and then there are insufficient grounds. Those are insufficient grounds.
Can you explain to me how they are insufficient grounds?
I am not going to do that today.
Okay, but I don't think that would be violating your surety bond and your oath of office to constitutionally explain to me how this is not insufficient when he is not representing me adequately.
I'm denying your request. I find you have been properly represented. I'm ordering that this portion of the transcript be sealed. Thank you very much. We're off the record.
Thank you, Your Honor.